Working in the adult entertainment industry means you should know the ins and outs of the laws that affect your work. Let's debunk some common legal myths so you can protect yourself and your business. Hi, I'm Alex Turry, a paralegal at Mink Law, the nation's leading law firm when it comes to online defamation and digital risk protection. I've seen firsthand how misinformation can disrupt a content creator's career or prevent them from getting the help they need. Today, I'm here to debunk common legal myths about the laws related to online adult entertainment. Myth number 1, I can use 30 seconds of copyrighted material without consequences. Myth number 2, once it's posted online, I don't have control of it anymore. Myth number 3, I'm in this photo or video, so that means I own the copyright. Myth number 4, an online platform can be sued for what their users post. Myth number 5, a lawyer will report me to the police if I tell them about my illegal work. Let's get started. Myth number 1, 30-second rule, copyright and fair use. Have you heard that you can use 30 seconds of a song before there would be any copyright-related consequences? Unfortunately, that's a myth. Here's the truth. There's no magical time limit that automatically makes using copyrighted material fair use. Fair use depends on 4 main things: why and how you're using the work. If you're using it for educational purposes, research, or as a parody, it's more likely to be fair use. What kind of work it is. If the original work is more creative, like music or movies, it's harder to claim fair use. If it's more factual, like news, fair use is more likely. How much of it you use. Using small parts is better, but if you use the most important part, it could still be a problem. If it hurts the original work's value. If your use could take away sales or hurt the market for the original, it's less likely to be fair use. The creation of content for profit or commercial use often weighs against fair use. So you can't use any amount of copyrighted material in the content you intend to sell. You may have also noticed that many online platforms will automatically mute or block video in certain countries if copyrighted music is detected. So, what can you do? First, always seek permission or licenses for any copyrighted material you want to use for videos that you sell. There are also royalty-free music libraries specifically designed for content creators. Some platforms, like YouTube and TikTok, offer built-in music libraries with pre-cleared tracks. What about live performances, either in real life or on a webcam? If the webcam show is not recorded or archived for later viewing or sale, there may be an argument that it falls under the copyright exception for ephemeral recordings. This allows for temporary copies of copyrighted works to be published in certain cases. If a live webcam show is recorded or made available for viewing in any way after the live broadcast ends, then the ephemeral exception would not apply. Webcam platforms may have their own rules prohibiting the use of copyrighted music as well, regardless of the legal technicalities. Violating platform rules could lead to suspension/banning, so make sure you double-check the terms of service of the platform you're performing on. The safest approach for creators is to only use licensed music, royalty-free music, or original music that they create themselves. Myth number 2. If you post anything online, it's no longer under your control. It's a myth that everything online is public domain or legally shareable. It's also a myth that leaks are impossible to track. While it may not be possible to prevent someone from screen capping, you still do have rights. Here's the reality. When you create content, you automatically own the copyright to that content, whether it's posted online or not. You don't have to register it with the government to earn copyright, but this process can be helpful in certain cases. Posting your work on social media or content platforms doesn't automatically transfer your rights to the platform or place your work in the public domain. However, you should always carefully review the terms of service of any platform you use. Some platforms may require you to grant them certain usage rights, which can impact your control over the content. For example, say there's a particularly vague clause in a certain website's terms. It indicates that it has the right to use your content for advertising. This website would take content that creators keep behind a paywall and show it on their affiliate sites as ads to bring in traffic to the main site. In that case, you can't use a DMCA to take it down because when you first joined the site, you checked a box that gave your consent for the platform to do this. To protect your content and privacy online, use watermarks or other identifiable logos on your content, regularly monitor for unauthorized use of your content, use DMCA takedown notices when you find infringement, and consider registering your copyright for additional legal protections. It's also important to be aware of content scraping and AI training concerns. Some companies may use your publicly posted content to train AI models without your explicit permission. Stay informed about these issues and advocate for your rights. Just because you're in the adult entertainment industry doesn't mean you should expect to be less in control of where your content ends up. Myth number 3, I'm in this photo or video, so I own the copyright. Actually, the photographer who took the photo or shot the video owns the copyright, even if it's your face and even if you paid them to take it. Seek informed consent about the entire process of a production and know your rights if you decide to revoke your consent. A solid content creation agreement should be made up of the following: a clear description of the content to be created, specific usage rights and limitations, compensation details, model release and rights of publicity, and termination clauses and content removal policies. An agreement should lay out the terms and what process to take should a performer revoke their consent. If you're working with a production company and you haven't been given a written contract, or it doesn't include the elements we talked about, that could be a red flag. If you need help drafting or reviewing content agreements, don't hesitate to consult with a lawyer experienced in adult industry contracts. Myth number 4, online platforms are legally responsible for the content their users post. Ever wonder why it seems like platforms get away with hosting harmful content? Can you sue a platform hosting content like this? This can lead to frustration and misplaced expectations when dealing with content removal lawsuits or online harassment. There's a law referred to as Section 230 of the Communications Decency Act. This law generally protects platforms from liability for user-generated content. That means if someone says something defamatory about you in a Facebook group, you can't sue Facebook. However, this protection isn't absolute. Here are some key points about platform liability that you should be aware of. Platforms aren't automatically liable for user-generated content. Platforms are required to remove certain types of illegal content when notified. And platforms can be held liable if they contribute to the creation of illegal content. Legislation like FOSTA SESTA has created exceptions to Section 230, particularly for content related to sex trafficking. This has led some platforms to be more aggressive in removing adult content, which can impact sex workers. As an adult content creator, it's crucial to understand your relationship with the platforms you use. Familiarize yourself with each platform's terms of service and content policies. Be prepared for potential content removal, even if you believe you're following the rules. Have a backup plan and diversify your platform presence, and keep records of your content and any communication with platforms. Understanding platform liability empowers you to navigate online spaces more effectively and advocate for your rights when necessary. Myth number 5, if I tell a lawyer about the creation of my work, they'll report me to the police. Many believe adult content creators operate in a legal gray area with few protections. But by knowing your rights, you can put the law on your side. It's a big myth that going to a lawyer means they'll turn you in if you've engaged in any illegal activity. In reality, a relationship with a lawyer is bound by attorney-client privilege. This is similar to confidentiality shared with a therapist, where anything you say to them stays between the two of you. There are a few exceptions to this, such as mandatory reporting. Some jurisdictions have laws that require attorneys to report certain types of information, such as child abuse or certain threats of violence, even if the information is learned through privileged communication. There are other exceptions, such as if you disclose privileged information yourself to a third party, you could waive your privacy for all communications. What you don't have to worry about, though, is your lawyer reporting you to the police if you disclose that you've done illegal work in your past. Your attorney's job is to help you and advocate for you. Operating in the adult industry doesn't mean you have to accept mistreatment or unfair practices. You have the right to safe working conditions, fair compensation, and protection from harassment and discrimination. Knowing your legal protections empowers you to advocate for yourself in your career. If you're facing a legal challenge or need guidance on your next steps, don't hesitate to seek professional legal advice. Our team understands the nuances of the adult content industry and can provide tailored support. Visit minklaw.com or call the number on your screen to schedule a free case evaluation with our intake team. Your work deserves protection, and you deserve peace of mind. Take the first step towards safeguarding your career today. I'm Alex Turry, and I'll see you in the next video.